A very good afternoon to each one of you. My name is Sanjay Kaushik and I head a company called Netrika. Netrika is a 10-year-old risk consulting company where we do manage investigations and dispute advisories. We are present in 7 cities in India and 3 international countries. Before even I touch base on the subject, I think I'll just ask each of my panelists to introduce yourself.
My name is Sanjukta. I head the legal team at LTI Mindtree. In fact, recently we have merged, Mindtree has merged with LTI. We are a 90,000 people company, $4.5 billion revenue. We operate out of 33 countries. And I'm really happy to be here. My experience has been over 20 plus years in the ITS industries with various companies, and I'm glad, I'm happy to join the panel, distinguished panel. There's only one thing, I think everybody is trying to get, everybody motivated. I think, I recollect, maybe we should play Natu Natu song here. And the second thing from the Oscars is the fact that, when Jimmy Kimmel was having his monologue, he also reminded all the presenters and the winners that, if they are exceeding their time, the Natu Natu team, the dancers will come and move them off stage. Maybe, ET should have planned for something like that. But thank you. Thanks for this opportunity.
Thank you.
Hi, this is Manohar Kamath. I'm part of the BASF group of companies. So I'm the general counsel for BASF group of companies in India. I'm also responsible for legal as well as compliance. So I think this topic today brings us a lot into the real, situations which general counsel are, let's say, bestowed with. And I think it will be quite a good session in terms of how we manage it, each one of us. Thank you.
Hi, good afternoon, everyone. I'm Sanjeet Kaur Batra. I'm the Group Vice President Legal for Cummins India. And it's an honor to be here. Thank you, ET Legal World, for having us here. And I look forward to an exciting discussion and hopefully an interactive session. Thank you.
Hello. Hi, I'm Anand Prasad. So I've been a lawyer forever. I probably am one of those few that has had the distinction of having set up 2 law firms. So one I set up about 24 years back, which is called Trilegal. And then I took a bit of a hiatus from the practice of law, set up a political party, which lasted for a couple of years, and then came back to the practice of law with setting up APN Partners. And I have essentially been an M&A lawyer, but as part of what I did as M&A work, there were a lot of compliance issues that have come up over the years, and I've seen how the Indian economy has developed over time and how compliance has become more important over time. So expect to share some of my experience with you guys, and feel free to fire away whenever the Q&A comes up.
Thank you. So we have a very, very diverse kind of a panel. We have people from the corporate councils, and we also have a law firm and a consulting organization like us. So we have a very, very diverse way, and what we are going to talk about is identifying risk and managing the internal investigations. So before even going to the topic, I think we need to understand, in today's days, earlier what used to happen was the risk or kind of things we were looking at was into silos. So some of the risks, say cyber risk, the CISO will look into. The brand protection or IP risk will be looked at by some person in the legal team. Somebody will be looking at the kickback or the whistleblower, or the background checks will be looked by HR. And these all used to work in silos. And the kind of risk which has gone up, now we're talking of enterprise risk management, bringing entire risk, whether it's compliance risk, whether it's any kind of a risk which could put you into a trouble, or the board want to hear that. And board has become, these days, boards have become much more proactive. This has become a critical issue where we are talking of the enterprise risk management. So, and when anything goes for the internal inquiry, the kind of frauds we are talking of today, And we were discussing this, just outside a couple of minutes back. There used to be conventional frauds. The conventional frauds were kickbacks, misuse of power, procurement-related frauds, thefts. All those are conventional frauds. But the new age frauds have changed the way we are looking at the frauds and the risk internally. And especially with the cyber frauds or the online frauds, the things have changed drastically. I was sitting yesterday with one of my clients here in Mumbai, and we were discussing about that somebody getting an email from a CEO desk, and this has been pretty common these days, somebody getting an email from a CEO, a CFO gets an email and the CFO just transfer the money, and later he comes to know that this email was never sent by the CEO. Besides this, there have been fake websites, ID thefts. Very interestingly, one of the banks came to us saying that whenever the people are going to Google and doing a search engine on the customer care number of the bank, it is not their customer care number coming up, it is the fraud number which is coming up. And person, when dialing that number, thinking that he's Googled it, he starts giving every information to that call center employee, which he thinks is from the bank. But he's a fraudster and he tries to get that number. And he takes all the information and the account is emptied. So the kind of frauds have changed, the things have changed drastically. So I'll just go back to my panelist, and we have people who work into diverse geographies, not only the diverse fields, but diverse geography as well. So Sanjukta, you have a lot of experience in working onto how the US investigations and the compliances work. So just if you would like to share your experience with that.
Thanks, and I'd like to address whatever I'm saying to all the younger colleagues out there. You really need to believe that you're going to be a GC anytime soon, right? And that's the most important thing, and whatever we say is mainly meant for you. There are a few things, before I get to the exact question. I think Manjari said that there are certain qualities that a general counsel, needs to have. And I think she said point of view, courage, integrity. I'd like to add presence of mind to that list. You need to think on your feet, and that's the most critical, one of the most critical elements as far as, that this topic is concerned, because presence of mind and thinking on the feet. Since we operate from US, as you know, if there are some colleagues from the IT industry, you will be familiar with this, that in the US and the IT industry, the two areas which are highly regulated are related to immigration and related to employment law. And you'll have class action lawsuits and immigration investigations which you may be faced with. Typically, what would one think that, any kind of government investigation starts with a subpoena, or you get an, affidavit, and that's about it, and you'll get your time, you will consult with, your external counsels, and then you'll be able to respond to that. Let me add here a new dimension, that you may be faced with a raid with armed policemen knocking at your door. Okay, so that is something that you really need to remember and be prepared for. If there are few areas which I like to touch upon, is definitely prevention, preparation, prognosis, and conclusion. Each of these areas you need to prepare for. Under prevention, I'll just take a minute. Prevention, you need to have your policies in place. Whichever industry, because some of us, move industries, but whichever industry you get to a leadership role or a senior role, please understand the industry and the issues that industry faces, and check whether, the company that you've joined has policies in place to deal with those issues. Number two is training in terms of preparation. You cannot, the emphasis on training has to be really high, because if you have a policy and you have a standard operating process and you have training, you can avoid a lot. And I'll repeat that, I'd like to talk about the oft repeated adage, which is, stitch in time saves 9, prevention is better than cure. It is critical. Second is preparation. When you talk about preparation, you need to have simple things, because I've been been with companies where the companies do not have a clear subject matter expert list with respect to your councils across the world. When you have, and especially for an Indian, headquartered company, we are a multinational Indian headquartered, we take the decisions from here, and you need to develop a proper list of expert councils for each region, network with them. Small things. I don't want to talk about big things at the moment, but in an investigation, they are your first line of, counsel and advice. And it's critical you develop that equation. It's not good enough, and I've seen this happen with in some of the companies. It's not good to take the service, ignore their invoice for 3 months, get reminders. It's not good. And I'm sure, colleagues from, the law firm will realize this. So if you do your job well, they are going to, bend their back, answer your calls, and provide that response. So it's very important to have that. Prepare, again, in terms of preparation, which is the second stage. Have a script ready for any kind of government investigation. Give that script to your senior business leaders who are there on the ground. If there is a raid, or there is an investigation, they should know how to respond. They should not feel helpless. And that is the value add you will give as a, legal counsel and advisor to the company. You also need, once you have these two, you then need to have a prognosis, understand the issue. Remember, I'll give you an example. In one of the companies, we had a, search warrant. So we had several locations and documents related to several to that issue were placed there. Critical, read, ask somebody on the ground to read. Don't let, because the government agencies and investigators will come and say, here is the affidavit, I want all your office to get open, and I want to check all of your files. Please read it. Are all those addresses which you are located in mentioned? If they are not, you are well within your rights to say, sorry, this warrant does not contain this particular address, so do not. Get your insurance policies, read the fine print on the insurance policy, as well as your limits, depending upon the industry. Once you have all of these in place, you will be better placed to deal with these investigations. Last point, before I hand it back is, when you have your councils and you select your councils, do not, depending upon the wide range of the issue and investigation, you can divide the responsibility among 2 or 3 councils. Get a second opinion, because you will definitely have somebody who's the best in the business and their top dollar you will have to pay there. But there may be other areas within that investigation which some other law firm can handle, and you divide the responsibility, you get to the solution faster. Of course, it takes time, it takes an effort, and you need to convince each of these law firms that, you will have to work as a team. They're not really used to working as a team. They take the responsibility, one law firm, but you need to see if that adds value.
No, thank you so much, and very important point that you need to be aware of the international laws which you just made, because there was just one case last week which come from US, that one of the expats traveling to India was detained at the Delhi airport because he was carrying some device which is very common carrying in US, but as per the Indian laws you cannot carry that. So you could be in deep problem if you are having that. Coming to you, Sanjit, on that is, how do you see and how do you identify risks within the organization, and then how do you try to mitigate those risks?
Thank you. And I think the first and the foremost thing is just to understand the business. Because as GCs, it's very important for us to go beyond legal. When we are talking of risk, we have to look at operational risk, we have to look at IT, legal, regulatory, financial, you name it. And we can't just be saying that we will limit ourselves to identifying the legal risks. So get to know the business, get to know the industry, get to know what's happening internationally. For example, what's happening at the geopolitical level, what are the sanctions that have been imposed, what is going to impact your organization in different countries, and then try to come up with a list. And also what often happens in organization is that each vertical lives in silos. But when we are identifying risks, what become very important, and I think that's a great value add that legal brings, because we are, enabling different verticals, is to look at the holistic picture and try to make these verticals talk to each other. Figure out what are the risks which are going to impact the organization from a legal and a regulatory perspective, from the financial perspective, reputation, etc. And then come up with, a clear accountability, clear communication about who is going to be responsible for which risk. And of course, there has to be a lot of collaboration between different functions within the organization, between different businesses. And also very important for us to understand the risk appetite of an organization, what the board wants. Is the board looking for a very risk-averse organization? Is that the advice that we are getting from the board? Or are we looking at a board and the risk appetite of the company is that let's take calculated risk? And there's a new concept that is now developing known as risk intelligence. So, identifying the risk, coming up with risk mitigation policies, making sure that if there is a crisis, are we prepared for it? We do things like, for example, have tabletop exercises. We have regular meetings looking at, what are the various risks, who's accountable for what, and making sure that if there's an investigation, if there's any kind of raid that happens, are we ready for it in all eventualities?
Thank you so much. And, talking of the risk intelligence, I think that's something which is very, very important and proactively. But despite doing everything, there are certain things which comes into, and then you're required to do the corporate investigations. So, Manor, I will come to you to ask that how do you manage the corporate investigations, and what's your experience in managing those corporate investigations and crisis management?
Yeah, thanks, Sanjeev. I think 2 points just to complete your question. I think there are 2 things which really, when you are evaluating a risk, I think first thing is the probability of that risk happening. I think that's very important when you kind of evaluate risk. And the second thing is what is the impact that it brings. I think if these 2 things you can also add on to your risk framework, that really helps. And maybe I say risk assessment is not a one-time exercise. So I think this needs to be a regular activity or a periodic activity. And I think the onus is primarily on, the people who are really responsible for, doing the job. So you can't expect a general counsel to evaluate all kinds of risk. I think the risk assessment has to be an activity of all the frontline people, all the people who are doing this job as part of their day-to-day activities, because they know their jobs very well. Yeah, I mean, the role of general counsel there probably is to make sure that, when such risks are being highlighted, how do you really bring this down to a meaningful conclusion, put traffic lights if possible, right? Because each risk comes with a probability and an impact, and I think that's the role where general counsels come in, yeah? I mean, addressing your question on crisis management, and I think how much ever we are prepared on crisis, it comes knocking at some point in time, and we need to be absolutely prepared for it. I think some of the things that probably, GC should look at, if not there in their organization, to have a crisis manual. I think it's very important that whenever a crisis comes, there should be a set process of how crisis is handled, because depending on which industry you are in, the nature and the type of crisis can change. Yeah. The second thing which I think is important is to have a crisis management team. I think you need, and there's no right or wrong, let's say, pick and choose kind of to who that team would be. But I think we need generalists and we also need specialists, because it's a combination of minds which comes together to decide how to mitigate or arrest the crisis. The third thing I think which is also very important to know that how serious the crisis is, because there could be certain crises where you could still take certain decisions after a thoughtful consideration. But there are certain crises, like for example, a dawn raid or a general raid where you need to be very quick in your decision making. And for that, what's very important is the part of training, which I think Sanjukta highlighted. And I think training is not limited to, only the senior management. I think training needs to be given even to the front desk people, the one who is at the reception. I would go to that level because he or she is the first person who comes in direct contact with the regulator. Yeah, and I think for that reason, you need to have a target audience when it comes to training. And I think that would basically clearly look at the preventive part. I think when it comes to the part of, reactive, when a clear crisis comes, you need to immediately decide based on what the type of crisis is, whether you have the internal bandwidth to investigate, because there are situations where you have a team, where you have experts depending on the area or the industry, or you need to go outside, right, for specific crisis where there is a technical aspect, or sometimes, you have competition commission. We see a lot of raids happening in the last 2 years in this field. So there definitely you need to have at least a good law firm, as I think Sanjukta also mentioned, that we need to have some panel law firms who have a wide area of expertise so that we can pick and choose which law firm would do the best justice in a current situation, and this has to be proactive. I think the whole gamut of service which the law firms are also coming up with has undergone a sky change. I think it's not the, even when you look at opinions, it's not the old-fashioned opinions. Now it's very structured and up to the point, and I think this has, at least as General Counsel, I see the expectation from the management.
No, very rightly said. In fact, I was reading somewhere, and I'm not a lawyer, with a disclaimer, I want to say that. I was reading somewhere that there are 267 laws which can lead you to jail or your directors to jail, and one of them is if your washroom is not painted properly. Does legal counsel actually have to look into all this? The answer is no. Again, the crisis management, again, a very, very important part that how do you handle to media? Who's going to answer the queries to media? Who's going to report to the board? Who's going to do what? If you're not planning it well in advance, and at times it is not necessary that you'll get everything within in-house. So you need to have, your outside counsels, your outside law firm, or consulting companies, and that brings me to Dhruv on that. Dhruv, you were late, so probably you can just take 30 seconds to introduce yourself, and then how do you manage the investigations? And we've been talking of dawn raids and CCI. How do you manage to the responding to the regulatory inquiries? If you can throw some light on that.
Sure. Thank you, Sanjay. Apologies, I was a bit late, but let me quickly introduce myself and the firm. Dhruv Fufale, I lead the disputes and investigations practice for Alvarez & Marsal in India. We are a US-based global business advisory firm, specialized in investigations, intelligence, and particularly handling high-level corporate matters. We do a lot of work with boards, we do a lot of work with investors and the lending community. 25 years plus of experience, spent over a decade in the US, and then came to India to set up a forensics practice for a Big Four accounting firm, and then built then joined Alvarez & Marsal, so been here for over 9 to 10 years. Have handled complex matters, including for the United Nations, Saddam Hussein's Oil for Food program, to all the way to when the Satyam crisis happened in India in 2009, one of our version of Enron that happened here. It was my team and that of another firm that actually did that investigation. So since then, it's been really a very interesting journey if we look at how financial crimes and the type of investigations have happened in the country in the last 15 years. And we've seen kind of a really nice evolution, but at the same time, some of the old problems still exist. Some of the things that we see in investigations, and I'll probably focus on things where I think at times where companies may go wrong when they look at investigations. is one is, there's a cookie cutter approach to investigations, right? That guys come in, you have 3 weeks to do this work and then give us the output so that we can table it and we can resolve it. And this is not just one company, different companies you speak to. Always the idea is, listen, we have to run this, we need to report to the board, so we need all investigations to be done in 3, max 4 weeks, finish that. Now, that's not the right approach in most situations. Of course, you will have 80% of the matters where you can finish it within those deadlines, but some matters may be complex. Some matters may need some more introspection to understand what is the source of this problem to be able to address it. So I think one of the things we are seeing some companies do is really spend some time in planning this thing really well. And why planning helps, right? For example, one of the things when investigators come in, we work with general counsels, we work with external counsel. One of the things we look at, okay, let's look at the books and records. Let's look at maybe some electronic data on emails and stuff. But is that enough? What are we trying to solve is going to be very important, because if we are trying to solve a supply chain issue, then you may want to think about intelligence. You may want to think about business intelligence. You may want to think about running some procedures through the supply chain. So it really depends on how you look at that investigation, which I think a lot of companies have evolved and changing, but there is still some problem in the mindset that we need to report, so we need to finish an investigation in 3 to 4 weeks. So that's one. Second, I think where we've seen also some evolution is, earlier investigation was looked at as a standalone basis. I've gotten a whistleblower complaint, or management has raised a concern and we want to investigate this, right? So let's put the investigation plan and let's execute it. But more and more companies are now thinking about, is this an isolated event? Very often we get involved and we say, let's look at your entire roster of whistleblower complaints that you received in the past year. Is there a certain theme that's coming out? Is there a certain trend? Is there a certain issue that's coming out from these? What do your internal audit risks say? What does the legal and compliance team talk about? What are the risks in the organization? These things often get missed, and what happens is, you do an investigation, you have a result, you have a report, it gets done, it gets tabled. Again, after 3 months, you have another whistleblower complaint. Again, after, it just keeps happening again and again, maybe from different sources, but the core issue exists and that needs to be addressed. So some introspection again there on looking at what is it that you're trying to solve for, right? That's very important. I think the third thing we've seen, there are 3 things I would to tell you is 1, 2, and the 3 is, what is the outcome of this investigation? Very often we are looking at, okay, who are the perpetrators? Let's find out why it happened, and then let's make some changes in processes and controls so that this doesn't happen again. But again, as we all know, in any organization, if 2 critical roles collude, you put in as many controls as possible, you put as many processes as possible, there is an opportunity of fraud. And today, in today's world, what we are also seeing is, the type of frauds have also evolved, right? We are now in a completely digital economy. A lot of us have seen earlier during the COVID period, after the COVID period immediately, you've seen a number of SEBI investigations that you've seen in the papers that pertain to situations that happened during the COVID period. And primarily driven because people were working from home. Now, those type of situations are unique. Today, after COVID, there's so much of digital, and the whole digital economy is moving at such a fast pace. KYC accounts are being opened by banks. Some of the financial institutions give it to third parties to go meet. For example, we're looking at a situation where it's in the agri-business, where this company is a digital company. They've created a huge opportunity. It's a very niche market, but a huge opportunity. The way they've gone ahead and done KYCs of farmers is they've taken the machines of these financial institutions, gone to the farmer, put in the Aadhaar card, put in this, and just get the whole KYC uploaded. The biggest problem in this was a complete sham of everything that was going on. Some of those records, the farmers didn't even know what was going on. So I think as we are also evolving as an economy, as we are evolving more and more digital, and India is probably one of the largest digital countries in the world, we are seeing different types of situations that come that need attention. So when you're planning an investigation, when you're executing an investigation, you got to make sure that you're understanding the core problem and you're solving, not just to get a report out for regulatory reasons, but you're also trying to solve for a solution to the business. The last thing is, we always talk about investigations, we talk about work papers, right? Very often we've seen, I don't know how many of you have seen in the papers, but a lot of the banks have conducted forensic audits. These forensic audits have been the basis on which then the banks have called to say, okay, this is a defaulter, is a willful defaulter, and so on. So many of those forensic audit reports have got challenged in the courts. And courts in some situations have also said that these procedures were not performed properly. So one of the biggest disservices when you're already spending the money on an investigation, when you're putting resources, your people's time and all of that, make sure that the way an investigation is conducted stands in the regulatory, in a court of law, stands in front of the regulator. Always think from that perspective is what is it that will take to kind of break this was my procedures complete or not? Again, the last thing is that it's...
We'll just come back to you, I think. Yeah.
Just to add on to, I think two things which are absolutely important here. One is, I think you need a one voice policy when it comes to crisis. So I think one important part which you should do internally is get a standby statement prepared. I think that's absolutely critical for organizations. And I think the second part, which is also very important, is how do you really come up with a plan which leads to minimal damage in a current situation. I think that's whether you do it internally or with the help of external counsel. The plan should be really to make sure that there is minimal harm or damage to the given situation.
I think one of the good ways is running the simulation exercises, which a lot of larger global organizations does that. And Dhruv, you touched based on the pointers of like the GCs and the CFOs coming to our office and saying that we needed this information as of yesterday. You don't have time. I think we need to really manage the expectations right. One of the large investigations we just concluded 2 months back, the CFO and the GC came to us and said, we have only 24 hours, can you do this? We said, yes, we can do it, but we can only give you this much in 24 hours, and then it took 3 weeks or 4 weeks to complete that, but we kept managing the expectations very clearly. And I think as an outside consultant or third-party consultant, it is also important to ensure to see that what is legal, what is not legal. At times, of course, you people are the legal guys and you know, of course, what it is. But we have seen that most of the time somebody will come and say, can I get the call detail record of this guy? Can I get the bank statements? No, those are illegal. We can't supply you something which is not legal. And I think, we as an outside guys, we have a lot of interfaces with the multiple clients at one given point of time. And we act as an interface between the GC, the company, the board, and the law firm. So Anand, that brings me to you. That what is your experience? How do you have managed the interface between the law and the business?
So it's interesting actually. So first of all, we live in a very interesting country with a host of very interesting cultural traditions, including when it comes to business. And think of it like this. You have a set of laws, but then you have a God called Krishna who says if it stands in the way, sometimes you can bend it. And that's exactly the way the entrepreneurial class in this country would think. It also thinks like that around the world. So I've got global entrepreneurs who say, all right, what is the law? How can we push it? What can we do which does not land in jail? Let's do everything else. Penalties, no problem. Break the law, no problem. This is exactly what you would be faced with. Now, 30 years back, 40 years back, when business was being conducted, we were a very low compliance country. We continue to be low compliance. Compliance is improving in the last few years. But what does that mean? It means that people said, never mind what the law is. Very often I don't even want to know what the law is. I'll get my advice, and no disrespect to chartered accountants, from a CA, I don't really need to speak to a lawyer. I'll go to a lawyer only when it comes to court. But let's just do what is necessary for business. And that is how the Indian entrepreneurial class thinks of running business. Now, with that mindset, you have the last few decades where suddenly there's been pressure. So the one-page contracts, or never mind this law, let's just do what we feel like because that is right for business. We've had a change in environment. Now, an important thing, and sometimes we as lawyers think, I mean, we are all trained as lawyers, so we think that we are very important and we are the thing to be. But really, we are, in terms of business lawyering, we are a support function to business. Our job is to allow for business to make money, as much money as they can, with breaking as few laws as they can. There is almost no business in India that makes money without breaking laws. So that's why I say few laws. Now, in that come the role for people like us, is that if you say, look, this is the law, and you start speaking up, then you get fired. Or somebody will say, this person is a showstopper, isko nikal do. So how do you sort of manage that? And therefore it is, and I think some of you guys said it is, how do you make it easy for business to do business while being compliant? So sometimes you have to walk the gray line. You have to look at interpretations that will allow you to keep a defense, but allows business to function. Business must get the sense that you are not a roadblock, but you are actually you're part of the business team. And just in terms of, and I was hearing conversations through the day. I have known general counsel that have become entrepreneurs. So when in the last presentation, I saw the last slide was an aircraft, I was reminded of Aditya Ghosh, who was general counsel and then went on to become CEO of Indigo, and since then a full-blown entrepreneur. And this is a story that exists in many parts of the world. The Indian economy is developing. Many of you, as you start understanding business and traverse beyond the law, you will have those opportunities that are not just legal, limited legal in their... But coming back to our subject, the question is, how do you deal with, one, the whole compliance regime? So how do I actually put in place a mechanism or a system that keeps the company more or less compliant? And it's not, you've got to remember that it's not good enough to say that this is what I want. You ask any business person, they'll say, I want to be legally compliant. As soon as they say a law stands in the way, they'll ask you, how do I go around it? So the question is, how do you build the system? The only way that you can truly build a system, you can as lawyers keep jumping up and down saying laws are being violated, but does your organization incentivize compliance? How many general counsels speak to HR or speak to senior management to say, look, there needs to be an upside? Now, what is it that drives compliance? One is just, how does your boss behave? Two, is there a carrot? So is there a bonus? Do I get some brownie points if I'm compliant? And three, is there a stick? How many strong managers who are good for business do you know who have been sacked because they have been non-compliant? The stick is almost never used, not just in India, around the world. So those are our realities when you come to actually building a system, is that how do you, therefore, the ability to use a stick against a high performer is very low. So therefore, how do you create a compliance around one just being very, very persistent with, we need to be compliant, but also how do you sort of speak to senior management and HR to incentivize financially or otherwise incentivize compliance? How does your senior management behave? Sometimes your senior management will be very brazen. In that case, you should consider switching your job, because if you think that you'll bring forth a compliance regime, you will not be able to. The workforce will follow leadership. So you can't actually bring about compliance in an environment which loves the idea of being a Krishna. So that's what you're dealing with when it comes to the compliance system. When it comes to crisis management, And crisis management is interesting because, again, a lot of what I have done over the years has been speak to senior management, deal with boards. Sometimes I have been on those boards myself. First set, and when you look at a crisis, you say, where does the crisis come from? Now, they are, by and large, I would say it arises in three kinds of situations. The easiest one to deal with is where you have been negligent. So somebody is not paid attention and there has been a transgression. Easiest one, so you can sort of say sorry, pay some penalty, etc., and move on. The more difficult ones are one which is in the nature of extortion, where you are actually the business victim. You are not the perpetrator. You have no option but to actually make a payment somewhere. And once you start making payments, you say, then why should I be in compliance? So that kind of culture steps in, but it flows from an environment that subjects you to an extortionist behavior. There's a gun against your head, and you therefore respond to the gun. The other one is where you're the bad guy. So you really go and fix things, and you don't try the legal route, but you are not necessarily the Krishna, but the Duryodhana.
So, Mr. Anand, we'll just come back to you. I think time is running very fast.
So
we
give
thought
me
that we'll talk about 2 questions, but I think we're just completing first of ours. So.
True. So just finishing that is how do you therefore, and how do you respond in each of those 3 situations will be very, very different. So you can't have one, I don't think you can have one manual that says this is how we respond in a crisis. It will change from business to business. It will change from what triggers the transgression.
Thank you. So, when we talked about everything, there is something which is very, very important is the one, if something is happened, how do we report it to the board, how the board needs to behave, and what is the discovery, investigation, the life cycle of the investigation, legal actions. So one concluding remarks from each one of you, if I can start from Dhruv, and then we can go in the sequence with the concluding remark, because the time is, the watch is really ticking fast.
Yeah, I think, if you are responding to a board, so one is if you're a board member, you need to make sure that you are really addressing the concern and you are looking at it you're introspecting properly and you're investigating it properly, keeping in mind all the regulatory obligations that will come in. But I think the entire discovery process has to be thorough, no shortcuts, and then internally company can decide what and how what needs to be told to the regulator.
Sanjukta.
I think from a US investigations, because that's the theme I picked up, discovery is huge. I've had a lot of experience on this. Please understand that every email, everything. You can have an audit, an audit team say, okay, we will do this audit. These are the things that, please understand that audit will also become, part of the public record. You need to ensure, depending upon the nature of the subject, please ensure that it is under privilege. If it is under privilege, and attorney-client privilege is the second most important thing you should remember from a US investigation perspective. If you put attorney-client privilege and have your attorney, in some states even your in-house counsel is part of this and some not, but if you have them, or engage, ask the auditor to do the audit, whether internal or external, under the attorney-client privilege, it's important because that will be kept off record. Discovery, ensure that all the emails which are copied with an attorney, even if you don't write attorney-client privilege, you can withhold. So these are some of the key takeaways. I just want to also say one quick point about 3 weeks investigation. I've had a situation, when the company, management said, I want this done and over with in 3 months. 3.5 years, and we have, it's not that, it's not a reflection of my, of my capability, but it's just the kind of, issue that
Correct.
sometimes one
Correct.
can face with. So experts, reliance on them, having a proper communication channel, all these are very important.
Thank you.
Thanks. I think from a reporting to the audit committee goes, I think all, compliance cases need to report to the audit committee. And then there, I think the committee clearly looks at not only, who is behind the, let's say, have you given the punishment to the right person, but also I think the process, the intent now is to clearly see what are the remedial measures that you put in place, because I think that's something which the board or the committee really looks at, yeah, and how you can learn from these modus operandis that people apply, and how you can share it within the organization. Because one of the roles of GC is not only to investigate, but also to make sure that the learnings from each complaint or each investigation is shared among the leadership team with a clear purpose and clear learning out of it. Yeah.
Sanjeev.
So for me, the biggest learning has been don't react, but respond. So, something happens, take a step back, because we live in a very ambiguous and a complicated world. There's a lot of interplay of different laws in the same situation. So one is, of course, the statutory laws, etc., which could have multiple facets. The second could be the company's internal policies, what is your code of conduct, etc., which has to be factored in. And it has to be a collaborative approach, because, again, it's not one person who would drive the whole thing. All the stakeholders have to get together and take a decision, understand what the implications could be, and then take it in the right direction. And at the end of the day, as GCs, I think there's only one path. We have to do the right thing. We have to make sure that we are, as the guardian of the organization, as the trusted advisors to the board and to the management, we have to do the right thing and make sure that whatever has to be done, irrespective of the cost. Of course, there's a risk mitigation in place, but you have to follow the law of the land and do the right thing.
Thank you.
So I would say three things. One is, in all these tough situations, make sure that you never yourself cross the line with the law. So it sometimes becomes very attractive to do the easy thing, but you've got to be very, very careful. An example is, let's say, backdate a document. Do not do that, come what may. Second is, if your crisis is in the public space, you've got to be very clear. We are a country that runs on media trials. Respond to the fact, recognize that. Don't start fooling yourself saying that we have a true blue court system that will be blind to what happens in the media space. So you do need to manage the media, and you need to have some thinking where legal and media management should go hand in hand very, very closely. And the third is, very often some of the transgressions go to the very root and very often to very fundamentals of how the business is run. What you need to be sure is, how do you actually have a solution for business? Because your solution can't be, while complying with the law, destroy the business. So that's not going to work. So that's the other thing that you've got to sort of work with.
Thank you. So I think just to conclude, what everyone has just captured is email discovery, and to manage how do we manage the records, and how do we use the client and attorney privilege into the communications. Reporting to the board and looking at the processes, something which is very, very important. Do not react but respond. I think that's what Sanjit has just mentioned, and do the right thing. I think that's important. Never cross the line, and I think this is one of my biggest statement. I'm a big fan of that. Never do anything which is against the law. You have to always follow that. And media trials, I think we have all seen in most of the cases that how media trials can impact the lives. Forget about the case when it will go for trial and into the court, but how it can impact the private lives and the emotional distress it can bring to the people. It's dangerous. So with that, thank you so much, my panelists. We can go to the questions. If anyone have, please, you can ask questions here.
Hello.
Yeah.
I'm Aman, and I'm working with Infosys. So I have a question here for the panel. So this is specific to contract review. In a contract, where there are warranties specifically made, that you would comply with all kind of applicable laws and whatever requirements are of the regulatory. And any breach of this particular warranty has repercussions to you, we giving up indemnities and it falling under the bucket of unlimited liabilities. and we are at a no deviation stage. So while there are approval mechanisms, there is a playbook which would kind of highlight at what level, which level, what approval is required. But purely from the perspective of kind of safeguarding the company, what do you think the risks are involved, and how do we basically address this, how to basically protect the business perspective?
I'll take that, but I'll say that we need a contract management and contract review session to answer this question. But typically what you can do when you're reviewing, your teams can say that you'll comply with applicable laws of your industry. Okay, or you have 3 clear areas. If they say you will comply with all applicable laws, I'm talking from a service provider perspective, you can also insert a provision which says the client will comply with all applicable laws related to the client industry. That way, you know, there's a clear division of responsibility. And sometimes you can have super caps in terms of indemnity and liability, include that if you're successful. You know, sometimes negotiations also involve charm. If you're able to convince, then you'll get them to include it in a super cap.
Yeah.
I think just to add on, one thing which we've also seen is many a times because of the other side, they have certain head offices outside India. Many of the laws they would want to build into the contract. Yeah. And even though, let's say, the contract is more done under the Indian soil, like, the US FCPA provisions, because they have headquarters in US. And I think there you have to really challenge. If the contract is purely performed in India, the services or the supply is happening only in India, then I think you can go back to your other side and tell them clearly that it applies to you, but it does not apply to us. So while, you can always have a blanket open clause, you can also go back and limit the exposure of laws to a particular contract.
I think that opens
So-
up a
so
very
if I
large-
might just-
It opens up a very large debate, because the client, as a client, you will say, okay, thank you, then we'll look for some other service provider.
So as an external lawyer, what I would say is there's a very long answer to this question.
Yeah.
And it depends on what circumstances you operate on. And at the end of the day, it is very hard from this stage to sort of respond to that in any solid kind of manner. But happy to chat if you